Good afternoon. We are going to go ahead and begin. So I'd like to welcome our representative from Perez Llorca to open up. Si quieres.
So dear students and dear finalists and dear trial and court, we are so pleased to host again this event, and my colleague Iraima there, who works with me at the HR team, we are always happy to have ES students, especially from ELSA, for this initiative. And these few words just to wish you all good luck, and we hope to see you soon during this process, the recruitment processes, and anything you need. There will be a cocktail afterwards the event, and we will of course be there to help you out with any doubts you may have. Okay, so welcome everybody.
And now our Vice Dean will address the crowd.
Hi, dear students, dear judges, and Perez Llorca, representative of Perez Llorca. Thank you so much for hosting this event. I just want to say that you are really our best ambassadors. If we are of anything proud at IE and at IE Law School, your alma mater, is of our students. And this is a great example of your passion, your commitment, your desire to be better and get engaged with your education. So what can I say? I'm really, really proud of you. I hope you the best of luck in this final round. And congratulations to all of you for being here. Thank you. Thank you for inviting me.
Thank you. And now some words from Luca Diaz, our trial director.
Good afternoon, everybody. For those who don't know me, I'm Luca Diaz, the Deputy Executive Director of the mock trial. I actually participated last year as one of you guys, and my team won the competition. I'm so excited for everyone to be here this year. I'm partaking in organizing it. It's really been incredible. I cannot wait for everyone to capitalize on the amazing opportunities that the mock trial and ELSA has to offer. And congratulations to everybody who's made it this far.
Almost there. Now we have Jorge San Juan, our Secretary General of the European Law Students Association here at the law school.
I'm sorry, I wrote a little something, so I apologize if this speech is slightly longer. So first and foremost, excuse my shortness. I know that you all want to compete and you don't want to hear any more speeches, but like Dane said, we're more than halfway through, so here's to that. When I was offered to do this speech, I was told that it would be a great opportunity to market the ELSA Law Review. I may or may not have accepted this opportunity because of it. However, before I get to that, I'd like to look back at this past year in terms of ELSA at IE University. It must have been October of late last year when Dane and I began the process of establishing ELSA at IE University. In the long, exhausting weeks that ensued, we must have had around 1,000 meetings with Eliza, with Soledad, with the ELSA Spain team, and our prospective members. And we probably spent tenfold the hours drafting the bylaws, our selection process, the website, the final projects. It was really, really, really hard. And with all the exhaustion, stress, and anxiety of it not meeting our expectations, when December came, we were both thrilled to see around 150-ish applications. Since then, safe to say, we have grown exponentially. Not only do we organize trips to other continents and bring premium guests to our esteemed campuses, but we also have created our two flagship events, the mock trial, which of course has grown and flourished so very much since our first edition last year, and our one-of-a-kind, groundbreaking, extraordinary law review. Follow us on Instagram at iLawReview. It is heartwarming to see such fierce competition here today. I wish you all the best, and I also wish for your application to the next edition of the review. Godspeed to all the teams. Thank you.
All right, I'm going to close off our speeches. So, first of all, congratulations to everyone. Most of you that are sitting here participated in some form this year or last year, and it's just amazing to see everybody coming together for our final round. Of course, I want to say an extremely special thank you to Perez Llorca for the amazing space, for the hospitality, and of course to IE Law School for giving us the platform to make this all come true. So the Mitchell L. McLean trial competition. So there is a name attached to this trial competition. I think it's very, very important that every year we explain why we named the competition the Mitchell L. McLean trial competition. So of course, as Jorge described, we founded ELSA together. So when we were thinking about what we could do as a flagship event, as our main event, I immediately thought about a mock trial. And being an American and being America-centric as I am, I thought, well, we should do it with U.S. law. So I thought about it, and we put this together because it's so important to. We have so many moots here at IE, but nothing focuses on common law, nonetheless U.S. law. So that's the theory behind it. But Mitchell McLean was a good family friend of ours when I was growing up. He was a judge in North Carolina. He was a Chief Superior Court Justice, and my 10th birthday wish was to spend a day in his office, spend some time with him. So as a 10-year-old, I was walking around to family court and criminal courts, and it was really incredible. And I really do think that this is what sparked my love for the law. Unfortunately, about a year and a half later, Judge McLean drowned in the ocean trying to save someone from drowning themselves, which he actually did end up saving them. But unfortunately, he passed himself. It was a very devastating time for our family and for me. But I do think that what he did was kind of what the epitome of being an attorney is, which is putting the lives of others ahead of yours, protecting people from injustice. I suppose the injustice in that case was the ocean, but I do think that his actions reflect what it really does mean to be an attorney. I mean, there's a lot of glamour, but there's also there's a fundamental aspect of protection. So everything that I do in law school is in tribute to Mr. McLean, Judge McLean, and I'm so happy that we were able to bring people together under his name and do what he did, which is litigate. So with that being said, we are in a Supreme Court round. We have our wonderful judges here and also in the second row here. Super excited to see how everything goes. And, I ask for the participants to just sit back and enjoy. Basically, just to go over the schedule really quickly, we're going to do, it's an hour per session. There are 2 sessions. So the first session will run for an hour. There will be about a 20-minute break. And then we'll have a second hour. And then we'll do our awards, and then we will announce the reception information at the award ceremony. With that being said, we are going to begin. I'm going to take a seat, and then we're going to call the case. Thank you. The clerk of the court will call the case.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Before we call the petitioner, we are going to just go down the line really quick. I'd love if the judges could just introduce themselves very quickly.
Yeah, hi everybody. My name is Lucas Bremkamp. I'm doing an LLM at IE Law School. I'm from Germany. I'm a qualified lawyer there. To work as a qualified lawyer in Germany, you have to do like 2 years of legal clerkship training, and this part of this is also being a judge. So I'm really happy to be back here, and I'm really looking forward to hear your arguments.
My name is Emily Keiler. I'm doing my Masters of Laws at IE as well, and I'm not 100% sure where I'm going to be in a year, so I'm just trying to find out what my life journey will be.
When the screen, then you're good.
Okay. Hello, Alexandra Vrede. I'm also from Germany. I'm also a qualified lawyer there, and I'm doing my LLM at IE Law School.
Okay. Hi, I'm Lola. I actually work here. Yeah, I'm doing criminal law in here in Perez, Llorca. So it's actually a lot of fun. And if anyone wants to work here, and after you have some questions, don't hesitate to ask me.
Hi, I'm Isabella. I'm also doing my LLM at IE School. I'm Dominican, and I fell in love with Moot in 2015. And ever since, I've been participating and judging.
Thank you very much. And then we'll introduce our second session lawyers at the beginning of the second session. We will now call the petitioner in 1323.
On June 19, 2013, Michael Jennings, an 18-year-old African-American, found himself in an exclusive neighborhood in Charlotte, North Carolina. He was driving a luxurious 2013 Mercedes sedan, a gift which had been bestowed to him by his father, who did not expect that the car model would make his African-American son, an honor student with no criminal record, a target of the police. On that unfortunate day, however, to the disluck of Jennings, Officer Roy Campbell, the defendant, was on patrol. Campbell, a 23-year-old white officer with an affiliation to not just one, but two racial purity cults, decided to follow Jennings for about half a mile and call for a traffic stop because, as he put it, Jennings didn't look right behind the wheel of that car. Campbell requested for Jennings' driver's license and vehicle registration, which he received, and then proceeded to unfoundedly and in violation of Jennings' Fourth Amendment right to ask the 18-year-old to step out of his vehicle. In defense of his rights, Jennings refused, and Campbell, agitated and rageful, shouted that he could pull anyone over any reason he wanted, especially those of Jennings' kind. Following, matters escalated, and Campbell proceeded to reach into the car and fire once at Jennings, leaving the 18-year-old severely wounded, something which Campbell later bragged about in the police station by stating that he had at least ensured that one of them, one African-American, won't be able to breathe. Honorable judges and ladies and gentlemen of the audience, today we're here to prosecute Officer Roy Campbell for committing a hate crime against Michael Jennings under Statute 18 U.S.C. 249. For this, we will explain why Campbell's actions perfectly conform to a hate crime and argue in favor of the admissibility of Campbell's body-worn camera as evidence. Addressing the hate crime, we hold that the argument that police officers should be granted uncontestable qualified immunity because of how these individuals take rapid decisions under stressful circumstances is unfounded. This is because precedent clearly establishes that qualified immunity is not uncontestable in circumstances where there has been a violation of clearly established statutory or constitutional rights of which a reasonable person would have known. The prior being the case of Officer Campbell, as he clearly violated Jennings' constitutional rights as granted by the First and Fourth Amendment, and therefore his qualified immunity is repealed. The actions of Officer Campbell breached the plaintiff's First and Fourth Amendment rights the moment in which he knocked Jennings' recording smartphone out of his hands, obstructing freedom of speech and violating Jennings' individual freedom from unlawful seizure. Jennings' Fourth Amendment right was further violated just by the mere fact of having been subjected to a traffic stop in which he was forcibly seized despite a lack of objective facts which supported Campbell's suspicion of car theft.
I'm just going to interrupt you really quick. First of all, are you holding any time for rebuttal?
6 minutes.
6 minutes. Okay. Just wanted to make sure. So in that case, we're at 22. Okay. So you talk about qualified immunity. Can you elaborate a little bit more on the concept of qualified immunity for a police officer?
Okay, so basically, given the fact that police officers are known to take quick decisions in stressful circumstances, the U.S. Supreme Court held in a case that they should be granted qualified immunity for their actions and therefore not be held liable if they harmed any civilian, which under reasonable circumstances.
So you talk about these reasonable circumstances. Can you explain a little bit, a police officer, when in the course of their duty does have to make quite quick decisions, and to link this prejudice, which takes perhaps some years maybe to form. How can you possibly say that every single action of a police officer, I mean, how can we hold a police officer accountable for a hate crime if every action is going to be independent of one another? Or are you saying that every action is linked?
That every action is linked to what, sorry?
So if we say that a shooting of an unarmed black man is because of prejudice, are we also saying that in that case the reason that he was pulled over was also prejudice, and the reason that he was even spotted in the first place was also prejudice? Or are we saying that the shooting is completely independent from the being pulled over?
As a prosecution, we understand that Supreme Court case Wren v. United States grants police officers the right to pull over United States citizens or any person in general in the United States that has committed any driving infraction. So we don't argue that there was not necessarily like that they don't have the right to pull someone over. We argue that in the case that they are pulled over, especially in this case, that there is also objective facts to back up the fact that they're being seized by the police, because there's also precedent which states that police officers in these types of scenarios should have a reasonable argument in order to take further action when stopping a car.
Okay, but is the petitioner arguing that that Mr. Jennings was being pulled over because he was black?
Well, we argue that according to the officer, Jennings was pulled because he committed a minor infraction while driving, which was not turning the signaling lights. However, we believe that after this happened, the comments made by the officer started to point that there was also some sort of racial reason behind the fact that he was pulled over.
But I'm sorry, but why would you then bring up the fact that he said that he did not look right behind that wheel?
Because it actually kind of serves as backup or serves as justification.
But I think the petitioner needs to clarify whether or not they think that was he or was he not pulled over because he was black. Period.
I think that the Supreme Court precedent is clear that
we're not asking for Supreme Court precedent. We're asking for the petitioner's stance whether or not he was pulled over. The car was pulled over because he was black.
We believe so.
Okay.
And when exactly did he start to violate the victim's rights?
Firstly, the moment in which, for example, the First and Fourth Amendment rights were violated, and the moment in which the police officer knocked out of Jennings's hands their recording smartphone, which like directly violates their right to freedom of expression, as held by federal law and also North Carolina law, which claims that people are actually entitled to be able to record encounters with the police.
So the moment that his rights were violated was when the camera was taken out of his hands.
That is one of the moments. Another moment was the moment in which he was asked to leave the vehicle because the officer did not provide or did not have any objective facts to actually support the fact that Jennings was a suspect of vehicle theft. Jennings had provided his driver's license, he had provided the registration, and it appeared because of the officer's comments that the only reason why he was being asked to leave the car was because the plaintiff mentions that or asked why was the actual motivation that he was being pulled over, and he mentioned driving while black, which completely exasperated the police officer.
But he's not charged for just pulling over someone and asking him questions. He's charged for shooting someone, and at that moment the victim pressed the accelerator. Was he still in violation of the victim's right at that point?
Yes, of course. For example, in President Torres v. Madrid, it is actually held by the Supreme Court or by the court that in the case of shooting, for the use of force, two things need to be held into consideration. Firstly, that the use of force is appropriate, and secondly, that it's not motivated by racial animus. Addressing the fact that the use of force was inappropriate, as established by Supreme Court case Tennessee v. Gardner, a police officer may not shoot a person unless he or she reasonably believes that the individual poses a significant physical danger to the officers or others in the community.
May I, and following up on my colleague's question here, when you classify deadly weapon in the United States, you're talking about firearms, knives, and also vehicles. Would the stepping on an accelerator, which could indicate perhaps that he's going to try and run the officer over, is that not perfectly justifiable to discharge a firearm?
Furthermore, the plaintiff altered? Wasn't he like showing signs of that he was altered? He was being, he was upset, right?
Like agitated, yeah.
Yeah.
The plaintiff or the defendant?
The victim, sorry.
Okay. Well, we basically argue that the fact that he pressed on the accelerator did not justify the shooting because, as seen in precedent, police officers are only entitled to shoot when the vehicle actually starts moving. The vehicle had not started moving, and the officer was the one who put his hand into the vehicle, which makes all of his further actions not in self-defense, but actually in an offense, because he knew that Jennings was the rightful owner of the vehicle, that he was unarmed.
Sorry, why do you think it was not in self-defense there? Because just putting my arm into a window in a car is not giving not the right to him just drive away, right?
It would have been in self-defense if the vehicle had started moving and he would have actually been pulled by the vehicle. But as is seen later on, he was not pulled by the vehicle, and therefore he had no reason to shoot. Also because of the fact that this was vehicle theft, it was no murder. So basically the fact that the defendant was not an actual threat to society.
But is not the stepping on a vehicle, even if it's not like in the gear, a threat? Because it kind of like imposes this noise that it makes, that I'm gonna leave, I'm gonna drive now, you have your arm in my car, I'm gonna drive regardless what you do. Is that not a threat?
We don't believe so, and in the case that the police would have perceived this as a threat, he should have warned Jennings that he was going to fire his firearm before, if he did not stop the car, something which he did not do.
Was the firearm drawn when the accelerator was pushed, or did he draw it after the accelerator was pushed? Do you know?
I think, well, because everything was so shaky with the body-worn camera footage, it is not exactly clear, but it all happened within the span of 10 seconds. So it could be said that it could have been like right at the moment, or yes, basically.
But doesn't the fact that he like fell back after the shot indicate that something was moving?
No, he fell back after the shot, because after the shot, Jennings, of course, scared, wounded, he actually started the car.
You do have 12 minutes. I'm just letting you know.
Okay.
I have a question. The facts say that Mr. Campbell was very young when the accident happened. He was 23, and that it was his first day of being on patrol by himself. Do you think this in any way influenced the whole situation?
No, we don't believe so, because an officer is trained to actually act rationally in these types of scenarios. If not, they shouldn't be given a firearm. Saying that because he was young is a reason why he actually pulled his firearm and he shot someone is not sufficient reason not to be hold him accountable.
Not necessarily because he was young, but because it was his first day of patrol by himself. Do you think that has anything to do with the situation?
No.
Let's talk about the hate crime a little bit. So a hate crime is not typically, and in fact, I don't know if it ever has been applied to a police officer in this regard. In order to prove the hate crime, at least I think that it may, I'm following the logic of the circuit court, in that you have to not only prove the first element, which is just because he was pulled over because he was an African-American man, does not mean that the shooting itself was racially motivated. So how could you, in such a short amount of time, which you said it was less than 10 seconds, correct? How could you properly justify, how could he have possibly gathered enough knowledge and racial motivation to make a decision to shoot Mr. Jennings because he was black and not because he felt like he was in fear of his life?
Well, from the beginning of the traffic stop, Officer Campbell failed to refrain from using insolent language. He justified his actions as proven in the body camera footage by stating that he could pull anyone over any reason he wanted, because especially those people of Jennings's kind. Additionally, he appeared agitated and aggressive every time that the plaintiff, someone who we believe he thought as racially inferior to him due to his affiliations with the League of the South and Kingdom of Identity Ministries, contested his authority.
Do his affiliations with the League of the South immediately make every decision that he makes forward a racially motivated decision?
Of course not. But in the case of Jennings, seeing his behavior even after the shooting at the police station, where he bragged that he had at least ensured that one African American would be unable to breathe, it is evident that he regrets not having committed further harm to Jennings just because of his race, and he acted solely out of racial animus. Now I would like to pass it over to my co-counsel.
Thank you, counsel.
Good afternoon. Now I would like to address the issue regarding...
If you could just speak into the microphone a little bit. If you can adjust it to make it a little bit more.
Can you hear me now?
There we go. Better.
Okay. Good afternoon. Now I would like to address the issue regarding the admissibility of the videotape of the body-worn camera that Officer Graham was carrying with him when the incident took place. So the respondents are claiming that the obtaining of the videotape was done through an illegal search of his property, thus violating the Fourth Amendment. The Fourth Amendment establishes the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. However, extensive case law regarding this amendment has established that this amendment can only apply against government officials acting in their capacity as agents of the state. And thus, it does not apply against private citizens who just illegally search through private property. Right now, we hold that Officer Graham was acting as a private citizen. And
How is it possible for him to be acting as a private citizen? Like, he was an officer. If he would not have been an officer, he wouldn't have been able to go and do the things that he did, harm the lock, and then access the video.
He would not have access to those lockers if he were not acting in the official capacity of a police officer. Is that correct?
But being in the station, wearing a police officer uniform, and being on duty does not imply that he's acting in representation of the police department. He's not acting officially as a police officer. Because
I think we're about to ask the same question. I think if he's wearing a badge, does not make him in the capacity of a police officer.
It is a police officer, but his actions are not official actions that represent the police department.
He undertook actions that he would usually undertake. He saw some crime like he had indication of a crime happening. He took actions based on that. So he did something that he would usually do when he's working. Other than the case that you cited, People v. Top, it's actually not something that he's doing that is extremely far away from his actual job. He did his job. He investigated a crime.
But he's not acting. He was not so he's not we're claiming that he's not a private citizen because he's the same rank as Officer Campbell. Therefore, he's not his supervisor, and he had no authority to just search through his locker.
Is there any scenario? Is there any scenario where a private citizen, an actual private citizen, and not an officer of the law, would be able to attain the body camera? Would be able to access the lockers?
Access the lockers? No, but that doesn't mean... So if we follow this logic that just because you're in the station wearing your uniform, then all of your actions are official police actions, then just stealing, for example, firearms from the evidence room would also be justified as official police actions, and that is a crime.
And I think I'd agree with you there.
Yes.
But he's not actually representing the New York Department, no, Charlotte Mecklenburg Police Department. He's acting on his own. His motive was a personal motive, a vendetta, actually, against Officer Campbell.
But your entire argument, petitioner, argument is that the motive of the hate crime was a personal motive. So how can a personal motive from the hate crime, a personal racial bias, be admissible in this court, but a personal hatred for racists not be admissible.
Could you repeat the question because I could not
Are you following what I'm trying to ask?
Yes.
Somebody.
Okay, so
I
you're
did not
saying
understand,
you're
sorry.
saying one of your main arguments is the fact that Officer Campbell acted because he was racial, like he had racial implications. He was you presented that he was part of two purity claim associations, whatever.
Yeah.
Yes, and you're saying that because he had that personal afflictions, he acted the way he did in front of Jennings. But now you're saying that just because Officer Graham had those afflictions of towards African Americans, he was acting as a private citizen and therefore should not be treated as a police officer?
I think the issue is that Officer Campbell, was on duty, carrying out his duties as a police officer by stopping the car. Officer Graham was not. He was not authorized to search through the locker. He was not ordered to do that.
Let me
He did
pose-
that just
let-
because it's like
Yeah,
stealing
please.
from a private house. That would be the exact same thing.
But he was investigating a crime. Was there not probable cause that he was getting rid of the evidence? Was he not acting in his capacity as a police officer? If he wasn't a police officer, he wouldn't have thought, oh, there might be a crime here. I might have to investigate it. He literally said, it rose suspicion. I wanted to investigate it.
But
If
he's,
he was
he's
getting rid of
not
the
part of
evidence.
the ongoing investigation. Therefore, he had no authority to
Does
do
he have
that.
the duty to investigate crimes?
If he's not ordered to, he could investigate, but not break into the locker. That's not
Let-
part of his
may,
duties.
may I pose a hypothetical for
Yes.
you? We're sitting here in Perez Llorca. If an attorney for Perez Llorca were to come here after hours, perhaps, and actually no, let's say during hours. It's lunchtime, dressed as an attorney, and goes and searches a fellow attorney's desk drawers for some reason, is dressed as an attorney, is employed at the attorney's office. Are they not acting still in their regard as an attorney to find these documents? I'm confused as to.
I don't think so, because he's not complying with his duties. He's doing whatever he wants. He's deciding to commit a crime. And he's just taking advantage of the fact that he works at a law firm and that he knows that person and he knows where that person keeps his things in order to commit his crime and have obtain what he wants. But that doesn't mean that he's actually following the law and being an attorney by stealing someone else's property. He's just taking advantage of where he works and the fact that he knows more information than someone that doesn't work at the police station, at the law firm in this case.
But in that case, if he really acted as a private citizen, let's just consider this. Wouldn't that just make the exclusionary rule basically useless? Because you could just take a bold officer and be like, just do it after hours, just make it look as if it was a private thing, and then everything that was obtained illegally would be admissible in court. This would basically weaken the Fourth Amendment right significantly. But it's such an easy circumvention of the rule.
But I think that arguing that Officer Campbell, I'm confusing the names, I apologize. Officer Graham was acting as an official, doing official actions will justify crimes committed in the station just because, again, he had the advantage of working there. So
But if he would act on his duty, he would have weight with the search of the locker, right? So is this affecting somehow your argumentation?
Could you repeat?
There was no reason for him just to search it right now. He can just protect and save the locker and get a warrant and search it later.
Yeah, but he could not have done that. He would need a warrant from a judge to his supervisor, and then his supervisor would have to order him to do that.
Yeah,
and he did not do that.
That's the correct way.
Yeah, that's the correct way, and that's not how he did it. That's why he's not acting following his duty, and he's not acting as he's not doing official actions as a policeman because he did not follow that process. That would be the correct legal procedure.
So you're arguing that because he was not following the right order and his duties, he acting as a private person, and this makes it possible to use the body cam as an evidence.
The fact is that they're arguing that it was a Fourth Amendment violation, and there wasn't, because he's not acting officially, because not just because of the fact that he didn't. Obviously, that helps that he didn't follow the legal procedure that is established in order to admit evidence, but also because his motive was clearly personal, and it was a vendetta. If he again, he had the
One
advantage
minute.
of work. Sorry?
1 minute.
Oh, 1 minute. Okay. So he had the advantage of working there, and so he knew information about him. He heard him talk. He heard him. Sorry, make racist comments. He heard him. He just disliked him, and he wanted to, as he said, he wanted to force that lying racist asshole to tell the truth for once. That is a personal vendetta against Officer Campbell. That is not an official policeman duty to do the right thing. No, he was just following his gut and his instincts without following any orders and without any authority. That's why he's acting as a private citizen, and therefore the Fourth Amendment right cannot be invoked, because he's not representing the state. He's not an agent of the state, which is what the case law establishes. That in order for the Fourth Amendment to apply, the person needs to be acting as an agent of the state, and he did not. There's also case law that says that officers off duty and that are not actually working or not carrying out their duties have done searches and counts as.
I'm going to have to cut you off, counsel. Are there any further questions from the bench?
I have one last one.
Yep.
You say that it was a personal vendetta because he said he wanted to force that lying whatever to tell the truth. Then again, you propose one of your arguments to be that the fact that Officer Campbell said that Jennings did not look right behind the wheel was made under official duties, like he was acting as an officer, but it was like if you're prosing both arguments one in front of the other, they both sound like personal.
But the thing is, I think the issue, the difference between both of those situations is the circumstances in which those statements were made. Officer Campbell was clearly on duty. He was acting as a policeman, and he stopped Officer Campbell as a policeman, exercising his capacity as a police officer, working police officer. Officer Graham did not.
Yes.
So, one exception to the exclusionary rule, I'm sorry I'm pondering on this, but is if there is probable cause that there is tampering with the evidence.
Mm-hmm.
And in that case, you can search without a warrant. And is that not what he did? He had probable cause. Did he not have probable cause to believe that when he changed the lock, when he lied about the evidence being in his locker or being in his possession at all, being there, did that not indicate that he was tampering with the evidence, that he was getting rid of this stuff, and thus make it possible for him to search without a warrant? And in that case, he was investigating.
Yes, but I think that for that exception to the exclusionary rule to apply, the search should have been done by a superior or someone with authority to do that search. He did not have authority because he's, as I said, as of the same rank as Campbell, and he was not ordered. He was not part of the ongoing investigation. There was an ongoing investigation in the police department to understand and analyze what happened that night. And he's not part of that investigation. Therefore, he was not investigating, and that exception to the exclusionary rule would not apply to him, but to his supervisors.
Thank you, counsel.
Thank you.
We'll now hear argument from the respondent.
Good afternoon. Honorable Chief Justice, and may it please the court, my name is Maxim Kudinov, and my colleagues and I are representing the respondent in this case. I will focus on the argument that Officer Roy Campbell did have reasonable expectation of privacy and that the search was illegal and inadmissible. And my colleague here will focus on application of hate crime and qualified immunity. But first, I would like to rebut the claim of the petitioners regarding the Officer Graham being a private citizen, so we can establish the applicability of the Fourth Amendment to this case. First, in Map v. Ohio, the court ruled that the Fourth Amendment to the U.S. Constitution applies not only to the federal government, but also to the state governments and police departments by extension. In both cases, People v. Top and State v. Walker, that the petitioner argues that apply here, the police officers were indeed off duty as they conducted searches of the premises of the police department. They were not in their uniform and they were not in the working hours. Both times, the courts emphasized that the officers were not a part of the narcotics divisions, which they called to conduct a second search after the private search was conducted. Furthermore, both of the cases, officers were established not acting in their official capacity were coincidental searches. Here, Officer Graham deliberately searched the locker, violating the privacy and aiding in the investigation. In addition to that, the petitioner argues that Graham's motive, quote, stemmed from a personal vendetta and not the need to succeed in the ongoing investigation, which is simply untrue. Since Officer Graham admitted that he hoped a more thorough investigation would follow once he discovered the camera. This emphasizes that his intention was to help the investigation, even though he did not have the authorization, and therefore he must be considered as an officer on duty and a representative of the police department and therefore state government. Now I would turn to establishment of the reasonable expectation of privacy for Officer Campbell in his private locker. In decision O'Connor v. Ortega, the court has concluded that the searches and seizures of government employees' private property by the government employers or supervisors are subject to the Fourth Amendment constraints. For the search to be illegal, the search should be in violation of reasonable expectation of privacy of the person whose property is searched, as established in Katz v. United States.
Question. You just said, you mentioned search by, you said government employers. Can you repeat that piece right there? You said something about government employers.
Yes. Searches and seizures of government employees' private property by government employers or supervisors.
So you just said government employers or supervisors, but Officer, is it Graham, was neither of those. He was not an employer. And in fact, he was the same rank. So that means that he also was not a supervisor. So in that specific precedent that you're referencing there, I mean, this wouldn't apply because this is a police officer of the same rank. So even if he was or was not acting in capacity of a police officer, according to this, I mean, it doesn't matter, right? Because he's not a supervisor or an employer.
He indeed neither, but my argument is that he is still acting as a government official, and therefore his actions would still be considered under this precedent.
But how could you link acting as a government official to acting as an employer or a supervisor? Because you can act as a government official all you want, but I don't think that necessarily equates you to acting in the capacity of as a supervisor or as the organization as a whole.
Sorry, could you?
Sure. You're saying that his actions as a police officer essentially equate to acting on behalf of the police department, correct?
Yes.
But how is that possible? In that if you act as a mailman, are you kind of invoking this like civil aspect of like strict liability of employees then? Like if a postal worker acts as when a postal worker delivers mail, they're acting on behalf of the mail service? Is that what you're saying? Like if a police officer acts on behalf of a police department, they're acting as the police department.
They are acting in representation of the police department.
In representation, but I think that the language that you're referencing says supervisor or employer. I don't think that it means representatives.
I think the question is Officer Graham bound by Article 4, by the Fourth Amendment? Does he have to apply with it? Or is it just the police department in general?
In accordance to the precedent that you're presenting. Given that you're saying it's only supervisors or employers?
Is Graham subject to the Fourth Amendment?
I believe he's still a subject to the Fourth Amendment since he's acting as an employee of the police officer, police department, and he is acting in his official capacity as a police officer, therefore representing the police department. And
we just asked kind of the same question to the petitioner, and they said like he was in breach of duty, he was not like respecting the procedure, how the search would have been done, right? So what makes you believing that he is acting as a police officer?
My argument here is that he wanted to aid the investigation that was going on in the police department, and therefore he was acting in his official capacity as a police officer, being within the station, going and breaking into the locker, the private locker.
But every police officer then knows, right, that... Actually, you continue with your argument, and then I'll pose this question in a minute.
Thank you. Our argument as a whole is that the reasonable expectation of privacy is applicable in default. This is supported by decisions of the court and established that the expectation of privacy can be limited with regulation or practice in the department, but by default, there is a reasonable expectation of privacy. In the instant case, there has been no evidence whatsoever of any regulation on the matter, and therefore the expectation of privacy for Officer Campbell does exist in his locker.
Was this expectation just not given up because he changed the locker, or he changed the lock to the locker?
To private lock. Yes, I want to address this with the precedent, United States v. Spites, where the court has actually decided that the established reasonable expectation of privacy when police officer used his private lock to secure the
But here
locker.
he changed
that
the lock. He changed the lock. There was no private lock before.
Yes, in the case that I'm referencing, in the police department, officers also used their private locks on the lockers, and therefore exhibiting their expectation of privacy in the locker.
But there is a difference between using a private lock from the start and changing from a state-issued lock that everyone else uses to a private lock after having after the fact that happened, after the altercate. Therefore, we're asking, why would he change the lock if he already had a reasonable expectation of privacy?
I believe that the fact that and the reason why he had changed the lock from a governmental issued to the private lock would be irrelevant to his expectation of privacy. By changing the lock to the private lock, he even more further establishes his expectation of privacy.
But if it's irrelevant, why would he change it?
It is irrelevant.
If I walk into IE and they give me a lock, I'm gonna assume if they give me a lock, either I do have expectation of privacy or I don't. If I don't think that this lock is secure, I'll bring my own. But if I bring my own, then I'm assuming that there is no expectation of privacy, which is why I'm bringing my own lock.
And furthermore, if I bring my private lock, I assume that there might be some investigations, which in this case he says, or you state that he was not assuming that there will be any investigations, just because there has been one prior investigation, which is kind of a difficult argument. If you say, I bring my lock, then you kind of assume that there has to be a following investigation. Isn't that true?
Can I say, if I understand the argument correct,
Yes.
you're arguing that by changing the lock to the private lock, he is manifesting that there would be followed investigation.
That he's expecting.
Exactly.
He is expecting
Yes.
the investigation to follow.
Yes.
He's expecting a search.
Because why would he change it then?
You would change to a private lock to prevent.
I don't believe that by that I don't believe that if the lock was changed by him, he would necessarily have the expectation of the lock being opened. I think that there might be many reasons, personal reasons, of all the things that police officers might store in their lockers, valuable items, and they would not want them to be opened.
But if they were valuable items and they didn't want them to be stolen, why not just use the lock the police department provided for you? I mean, it's just a safe, right? Unless you have this reason to believe that maybe my supervisor does know my combination, or maybe they'll break it.
Furthermore, he changed the lock the day after the incident. Isn't that indicating something?
It might indicate that something is going on with his locker, but I still don't believe that this affects that the Officer Graham within his search had a right to open the locker and therefore get the evidence within the legal way. And then I believe that because of these actions, the evidence should be suppressed, as has been established in the Court of Appeals reversed.
Can I ask another question? So you argued before that Officer Graham could not act as a private person because he was in his uniform in a police station. On the other hand, you claim that they have a right to privacy in that sense. But if your employer, or if the police department offers you a locker with a lock, and it requests you to store personal things, or certain things there, like your clothing or maybe your cameras, is that not part of your job? Is that not part of your employment there, which indicates that it is actually not your private sphere? It's not your personal bag that you store stuff in. It's not. You might put your personal bag there, and if they search the personal bag, that's another thing. But if they open the lock that is provided by the government with a lock that is put on there so that a janitor can open it and stuff like that. I think you cited that case as well, where it is a non-investigatory search, or the other party did. So there is reason to believe, if they provide you with a lock, that someone might be able to open it, be it if it smells bad or something is leaking or whatever. They provide you with a lock because they want to be able to open it in a certain sense. They provide you with a lock and show you this is part of your job.
I want to distinguish between the non-investigatory searches by the employers. Those cases are mostly focused on offices within the departments or anything, and desks and files if the employer wants to find a file. But I don't believe that this is the same thing as having a personal locker that is assigned just for you with a lock.
Let's dive into that a little bit, because really what's on the table right now, or the question on the table, is a file. It's an MP4 file, right? It's a video file. So how, if you are allowed, under your argument here, if you are allowed to search to find a file, would that not be searching to find a file? I mean, I'm looking for a video file in this body camera, which is the property of the police department.
Yes, but this search has not been made with the purpose of making the efficiency of the department better. It has been made with the purpose of aiding in the ongoing investigation against the person whose locker this is, and therefore it is not the same as.
But was Officer Graham part of the ongoing investigation?
No, he was not, and this.
Furthermore, isn't the locker there for officers to store their private items?
15 minutes.
As my colleague just said, the body camera is not a private issue of Officer Campbell. It's state property. If he had it there, why would he have it there if the locker is supposed to serve for officers to store their private items?
This would be an infringement by the Officer Campbell, and this is not the issue here. I want to also distinguish between our arguments, that we are arguing that the exception for the search, for investigatory search, should not apply to Officer Graham because he did not have an authorization for to conduct this investigatory search. But we believe that the exception for investigation under O'Connor was made for official investigatory searches for supervisors and employers, and Graham was neither. But the fact that he did not have authorization does not void the fact that he indeed was acting in his capacity as a police officer, which is supported by his hope and desire to aid within this.
May I pose a hypothetical here, real quick? What if Officer Graham was just opening up the private lock that Officer Campbell put in his public issued locker, just because he thought Officer Campbell was going to steal the body camera? What if he just was preventing Officer Campbell from committing a state theft?
For this, there has been established precedents that if officers believe that the evidence might be destroyed, or
I'm not talking about destroying evidence. I'm not saying that he was going to destroy evidence or anything else. I'm saying that what if Officer Graham thought Officer Campbell was just going to steal the body camera? He was going to take it home and use it for personal matters.
Not even take it home. If the locker actually was his private sphere, he was stealing state property, there was probable cause. Because if that is his private sphere, he removed a state item out of state sphere into his private sphere.
Furthermore,
It's like
put a private lock on it.
I believe that
it would be. I mean, just to follow, I think it's almost similar, and you can rebut this, of course, that it would be just the same as if he had gone and put it in his car outside of the police station.
Exactly.
Or placed it in his personal bag inside of the, because as I read in the district court's ruling, it was factually decided that there was a requirement every day at the end of the shift to place that body camera onto a charger for it to upload, correct? So not only are you stealing maybe the body camera, but also maybe the files or the documents of the police department.
But the fact that he was possibly committing another offense does not deny the fact that when the private locker was opened, whatever it might be there, the Officer Graham already had infringed on his privacy
When
rights.
there is probable cause, officers can search without a warrant, right?
I believe so.
Okay, so if there was probable cause that Officer Campbell was committing state theft by stealing the body camera, wouldn't it make it justifiable for Officer Graham to have opened the locker?
I don't believe that was the reason why Officer Graham had went to the locker and opened it, not because he thought that it has been established in the district court that his whole intention was to prevent him to possibly destroy the evidence. And when the officer has this intention, they can go to their superiors, they can secure the locker until the superiors can go there and legally.
Isn't obstruction of justice also a federal offense or a state offense? Obstruction of justice?
They're both.
Yeah, so if Officer Campbell was committing obstruction of justice by safekeeping the evidence, wouldn't it be also probable cause for Officer Graham to go into the locker? Like, that's another completely different crime.
Can I just clarify to see if I have your argument correct? Yes. Are you saying that because there was no concrete or physical evidence that did Officer Graham know for a fact that the body camera was in the locker, or was it more on a suspicion?
He just had a suspicion.
A suspicion. Okay, that's all I needed to know. You have 10 minutes, by the way.
If I may, to give my time to my colleague. Thank you so much.
Thank you, Counsel.
Chief Justice, and may it please the Court, I'm Matilde Romagnoli, and I will explain today why not only the police officer did not violate any constitutional right, but also why he did not violate clearly established rights. Starting from the second element, in claiming that the qualified immunity shall not apply because the action of the officer violated clearly established right, the petitioner does not mention what well-established rights in relation to hate crime they refer to. This is because, indeed, there is not clearly established right as per Supreme Court definition, according to which even if a police officer is found to be violating constitutional right, the petitioner should establish that these rights must be sufficiently clear set by Supreme Court precedents that a reasonable officer will understand that they are violating a constitutional or statutory right. This entails, always per Supreme Court and statutory definition, that the facts of the case needs to be factual identical to the precedent in question. There is no such case, and the most similar one, Gordon v. Brienga, that saw a policeman shooting at a man after stopping him for minor traffic violation, has been granted with qualified immunity in 2020 by this court, which in respect of the enhancing force of the statutory stare decisis referred to catch-22 principle, no precedent, no clearly established law, therefore no liability. As the case mentioned, more than other 25 times, this court has granted qualified immunity to police officers' accusation of constitutional rights violation. Despite this, we claim that not only the police officer has not violated any clearly established right, but he has not even violated any constitutional right. This is because hate crimes, by definition, entails the willingness to harm because of race. As this court held in Warren versus United States, personal motives of an officer to stop a car are not a factor in the court's Fourth Amendment analysis of whether the cause for the stop is sufficient, and the standard for reasonable suspicion is purely an objective one.
May I interfere there for a minute?
Sure.
I think I'm going to pose the same question we asked the other group, because, or the petitioner, because stopping the car is one thing, and then shooting is another. Are these actions linked? Is it one case, or is that maybe like two separate actions? Because you only refer to the stopping of the car, whereas the shooting happened later, when after he manifested for several instances that he did, like that there were several circumstances indicating that he had a problem with black people.
Thank you for the question. In first place, when it comes to the car stop, as I already mentioned, the only objective grounds to define whether that is lawful is whether the driver had committed a traffic violation, which indeed is the case, and this gives to the officer a legal ground. When it comes to the shooting, again, there is no proof that the driver was shot because of his race.
Isn't there?
Sorry?
Are you sure?
There?
The two things are not linked. The fact that the
but are the comments made about preventing the breeding, does that not even retroactively suggest that that the shooting was with race in mind?
When it comes to hate speech, specifically related to the words of the officer, Cinder versus Phelps established that hate speech is criminalized when it carries a threat of violence explicitly, which was not the case.
But I would say that preventing someone from breeding is quite a threat to me.
It might be, but this doesn't entail and doesn't show that the shooting of the police officer was related to that comment. And on top of
Furthermore, can we discuss the comments that he did not look right behind the wheel of that cart?
Again, as mentioned, under Warren versus United States, this is completely irrelevant because the only objective standard to define whether the stop was lawful was whether there was an infringement. And any subjective comment or any subjective motives, as established by this precedent, is therefore illegal as far as there is a ground for the stop, which indeed there was.
I mean, a stop is not in question here, I think. We all can agree that maybe for some reason or another there was a traffic violation, he stopped the car. Like, I really don't mind, but the shooting and the actions before that shooting, I think that is what is crucial here in this case. And we have the voice recording where he issued several, where he made several statements that might indicate that he had a racial background. It's not just like stopping the car, it's the way he acted after. Why did he feel threatened? Why did he feel threatened by an 18-year-old who did nothing wrong?
In addition to that, the fact that Officer Campbell actually got really agitated after Jennings asked if he was stopped because of driving while black, doesn't that suggest that there was some racial implications in the matter? Doesn't that suggest that Officer Campbell was acting on some racial implications?
Absolutely no, and I'm going to explain why in 2 points. The first one is related to why he felt threatened. Risk assessment for police officers are established, as the other side mentioned, according to whether there is a risk for the driver to escape, which we argue there is, and also based on the training and experience of the officer in making such assessment. We claim that perhaps there might be a chance that the officer excessively considered the risk and might misapplied the use of force given the circumstance. Therefore, however, per Supreme Court precedent, Kisela versus X, a misapplication of the use of force has to be established from the point of view of the officer. Given the training received by that officer and given the elements such as the feet on the accelerator and so on, we believe that the officer had reasonable suspicious, according to his experience and the factual elements, to believe that there might have been a danger for them.
May I ask an exploratory question real quick? So you're saying that just because the fact that Mr. Jennings had his feet in the accelerator, it was reason enough for Officer Campbell to shoot him?
That's just one of the elements. As I mentioned, the totality of the circumstance needs to be analyzed. This is certainly one. The second one is the training of the officer. He might have miscalculated the risk, which is why police officers are granted to immunity, because this is something that can happen. And on top of that, the police officer did not have any time to establish whether the driver was carrying weapons, which might have aggravated the circumstances when it comes to the calculation of the risk.
But actually, I'm sorry, don't you think that the fact that all the elements that ended up with having the car stopped, and the fact that he followed the car, made sure that he committed, didn't make sure, but waited until someone committed the crime, like didn't stop, then threatened him kind of, and then put the hand inside the car and all of that, don't you think that all those elements should be taken into consideration and be considered as something that is like threatening to the
No,
victim?
because this court has established in Warren versus United States that this falls within a subjective sphere of analysis for the causes of the stop. And this court, in the mentioned precedent, has established that it's completely relevant. And what matters is, as I already mentioned, whether there was sufficient ground for the stop, which, again, there was.
Sorry, but you were saying that he was, like, he had a lot of experience, but we actually said that he only had 23 years old. That he was only 33 years old. Yeah, so you were like, I think you said he had a lot of experience, which I think he doesn't, because he's only 23 years old, and also it's his first day alone. And then the fact that you also said he maybe miscalculating those 10 seconds, the actions that because of his training, he like aren't they trained to be able to make those decisions in those 10 seconds?
Yes, and but also the law recognized that sometimes, given the circumstances and given the stress weight that police officers carry in making such a decision, they might be over-calculating the risk or miscalculating it. And that's why they're granted immunity.
But don't you think there should be boundaries? If you say, yes, it's from a subjective point of view from the officer, don't you think there should be any boundaries? Because don't you think, or do you think there is any way that the officer waited for something to happen? He saw he was black, and he, from his personal point of view, thought it would be right to wait until something happens, until the driver makes a mistake.
Your Honor,
you are out of time, so answer this question and then you'll be done.
May I ask another?
Can,
okay.
Your Honor, the only boundary here is the law and the requirement of clearly established right. That is where the boundary is set. And as a matter of fact, there is no clearly established right per Supreme Court precedents and according to the statutory definition of qualified immunity for not granting the police officer qualified immunity indeed.
You repeated in various occasions that the whole situation had to be considered. Like, you have to see the situation as a whole, not like as different things, right? Then you proceeded then to say that the fact that the police officer was following the car, waiting for until they made something wrong, they made a traffic matter, that the fact that the police officer entered his arm into the car And further on, that the fact that the police officer made Jennings drop his phone were irrelevant. Can you please explain why are those facts irrelevant, whereas the fact that Jennings had his feet in the accelerator has to be taken into consideration?
Sure.
And if I can add to that, Officer Campbell said afterwards, I quote, at least I made sure that one of them won't be able to breathe, right? So also, how does that match?
If I may answer to this question first. This is protected under the First Amendment for the police officer, because it's clearly something that represents his point of view, and it doesn't constitute either as hate speech according to the definition, and it doesn't even qualify as frightening speech. So it doesn't carry any explicit threat. We may read one if we please, but this still doesn't preclude that the clearly established right requirement is not met, and therefore qualified immunity shall be granted. Yes. Could you quickly repeat the question, please?
For sure. You stated basically that the whole situation has to be taken into consideration, yet you said that the facts that the police officer followed the car, that the police officer entered his arm into the vehicle, and that the police officer made Jennings drop his phone were irrelevant.
Yes.
How are those facts irrelevant, but the fact that Jennings had his feet in the accelerator relevant? Like, why? How are you making that distinction?
I'm quickly addressing the car, and then I'm going to go with everything else. When it comes to the car, it's this court that establishes that any subjective reason is irrelevant. Because as I said multiple times, there was a legal reason for the stop. And regarding the arms and regarding the phone, two things. If the courts decide, which we don't think so, that this is a violation of any constitutional right of the driver, there is no clearly established right that shows the links between these actions and any possible hate rationale for the police officer, for him to clearly understand that the action that the police officer was carrying on were something that will constitute, according to the definition, something that will have violated consequently the rights of the driver.
Can I ask one last question? So we understand that qualitative immunity is granted to a police officer who is exercising his duties, right? And you argue that he was prosecuting a possible crime there, a theft of vehicle. But at the point where this happened, there was nothing pointed to a crime anymore. Maybe at the moment in time where he pulled the person over, okay. But at that point, the victim already had provided his license, he had provided the car registration paper. He had no suspicion whatsoever to that crime anymore, other than the fact that the victim was black. What else was his motive?
That he was trying to escape from the police officer, potentially harming the officer himself.
But why would he escape if he did not commit a crime?
It was not clear yet that he did not commit a crime, and he might be escaping for any other reason, which in any case it will be irrelevant because it's illegal to escape from any type of seizure. So we don't believe it's an element that should be assessed in this circumstance.
We are out of time, so we are going to dismiss the respondent. Thank you. We have 6 minutes for rebuttal for the petitioner, and then we'll be done for the first session.
So, Your Honors, I would quickly want to address the reasonable expectation of privacy as mentioned by the respondent. As my colleague already established, Officer Graham was not representing the state, and if he's not representing the state, then the Fourth Amendment does not apply, which is where their motion to suppress the evidence has no basis, because evidence obtained illegally by private citizens that are not acting as representatives of the state does not trigger the Fourth Amendment, and can be admitted into a court as shown by precedent. Due to the lack of time, I would like to focus on the arguments presented by respondents regarding the hate crime. So, constitutional, they argue that there were no violations of constitutional rights and that the rights were not well established. So we argue that constitutional rights are well-established rights which law enforcers must be aware of. The respondents mentioned that police officers have to be well-trained. This training would certainly include being aware of these constitutional rights which he violated. As my co-counsel previously established, that they were the First and Fourth Amendment especially. This training would also give him the capability to act in stressful situations. There should be boundaries to immunity. This is when the violation of constitutional rights comes up. Everyone is subject to stress and comments which perhaps may alterate them. However, not everyone has a gun. Policemen do and are trained on how to use it. Hence, they must be held at a higher level of accountability.
How did we know that Mr. Jennings did not possess any firearm?
Because he did not in any time show to be posing a threat of using any type of arm or any type of violence. When he was asked for the documents,
Is the car not
yes, but the car, I believe...
a weapon in that case?
I agree that the car is a weapon, but when the documents were asked for and previous action shows that he was not willing to use the car as a weapon against
But
the
didn't he
officer.
had his feet in the accelerator?
He had his feet on the accelerator once the officer reached into his car without any reason for doing so, because the documents had already been provided and there had already been established that he was not liable for.
But even if the officer hadn't or had put his hand into the vehicle, I mean, I don't see how that does or does not justify him placing his foot on the accelerator.
But he did not actually, the car was not in movement.
But how would you expect if you, I mean, we talk about this 10 seconds and the shooting. How can you expect a police officer to be able to evaluate whether the car is moving or not when it's the second you hear the rev of the engine? Aren't you going to automatically assume that the car is going to probably move?
But then he should have warned the victim that he was going to use to shoot an arm and to use his arm and to use the power of threat as established by as is the common procedure.
But we've talked about the 10 seconds. What if the officer had any fear? What if the officer felt threatened that Mr. Jennings had a gun or something? Like, wouldn't the announcement make it easier for Mr. Jennings to reach his gun and to attack the police officer?
But what would be the fear? Because he had already acted and proceeded in every way that the officer had told him to proceed. And there was no...
The fear would be that Mr. Jennings was revving the engine of the car, thus provoking a threat to the officer.
I don't think that sole thing can trigger a shooting. That when he maybe heard the rape.
Let me pose something. I just need yeses and nos here, just for the sake of time. If a person reaches, for example, here, is that enough to pose a threat to an officer?
Not necessarily. Like, it depends on the circumstances.
So I'm gonna move my arm here. Tell me when it is a threat.
Yeah, maybe it is a threat, but then the police officer should have said that he saw that as a threat and that he was going to enact violence against him.
But can you just answer?
Yeah, I agree that
this is a threat.
Yeah.
So would the revving the engine almost be like reaching into your pocket, right?
Yeah.
It's like you're telling the officer you're going to start the car soon.
Yeah.
It's a signal of a threat, right?
Furthermore, you're threatening an officer of the law. Like, that's something you have to take into consideration here. It's not any person that you're threatening with the revving of the engine. You're threatening an officer of the law. How would you justify that?
Sorry, can you repeat?
How did you justify the fact that Mr. Jennings was threatening an officer of the law by revving the engine?
I think that that the fact that the car was not totally in action did not pose the bigger threat. I think that it might pose a threat, but that the principle of proportionality, like it was not reasonable for him to shoot if the car was not in movement and it was not posing an imminent threat to him at that particular time.
Wasn't the victim upset about the situation? And was the officer not on foot and the victim in the car, and the car weighs a lot, revving the engine kind of implies, I'm running you over?
I don't think it implies I'm running you over. I think it may account to a threat, but I don't think that threat is sufficient enough for a shooting, like a violent action towards him, like a shooting to him towards him to take place. Sorry.
I have two questions, just yes and no. So the qualified immunity doctrine has two requirements.
Sorry?
The qualified immunity doctrine has two requirements, right?
Yeah.
Both are met in this case.
Yes or
yes.
no?
Yes.
Okay.
We're out of time. Thank you. The court will come to order. The clerk will call the case.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, clerk. We will go down the panel here, and the judges will give a brief introduction. We'll start here on the left.
Hi, my name is Laura Rushton. I'm originally from South Africa, and I am currently an employee at, well, Practicas or trainee at Perez Llorca. So if any of you are interested, please feel free to come and ask us any questions. There are a couple of us acting as judges today.
Hi, I'm Beatrice. I also work here in Perez Llorca. I work in corporate law, so if anyone is interested in that, ask me later.
Hi, my name is Mark. I also work here in the litigation department, and good luck to all of you.
You know me.
Hi, everyone.
Oh, there you go.
My name is Yaqi Ma. I'm from China, and I am currently an LL student at IE Law School, specializing in international dispute resolution. I also studied laws in China and the US before.
Do you want to introduce yourself?
I think most of you know me as well, so my speech from earlier, I think, was enough.
Wonderful. This is 1323B. We will be calling the petitioner for argument.
Dear Honorable Justices of our Supreme Court, and if it may please the Court, we would like to begin with a fact. Black Americans are 3.23 times more likely to be killed by the police than white Americans. The question of whether a police officer's actions can come in the course of their in their employment can constitute a hate crime under 18 U.S.C. paragraph 249 is a case we will examine today with Officer Roy Campbell, a racist, rule-breaking criminal cop. It is essential to understand that there is a clear nexus between the cop's racism and the cop's actions. And if we divorce this, our law is not just. We cannot divorce the shootings of Jennings and the racism of the cop. They cannot be separated. He was black, and then he was pulled over, and then racist remarks were made, and then he was shot. And then Officer Campbell continued to make racist remarks after he was shot. The events weren't independent, and they were one stretch of events that show that Officer Campbell was racist through and through his racism and his exertion of force, which in the United States should be only used in two very specific circumstances, through his exertion of force, committed a hate crime. The backdrop against which we find ourselves is the highest scrutiny of law for law enforcement, a global climate of mistrust in America, and an urgent call for accountability. In this context, we assert that police officers must indeed be held accountable under the Hate Crime Act because of the doctrine of equal protection. All citizens, regardless of their standing in the United States of America, should be held accountable because of the equal protection doctrine. This assertion is not only grounded in this legal doctrine, but also the principles of transparency, fairness, and the evolving societal expectations regarding police conduct. The first argument we made is about the equal protection doctrine, which is, if at all, should Officer Campbell be held responsible for a hate crime? And our argument is yes, unequivocally. Officer Campbell is an upstanding police officer that should be held to the same standard as every other citizen. And the reason this applies and the reason that qualified immunity would not apply at all is because Officer Campbell breached the constitutional
Under your
rights.
logic, why has no other police officer been charged with a hate crime then? I mean, you just said that black Americans are much more likely to be targeted by the police. That sounds like statistically there should be another case where a police officer was charged, but we don't have a police officer that has been charged with a hate crime yet, have we?
No.
Perhaps in one case, perhaps the Floyd case, but I think that that's still under appeal.
Yeah, so we haven't seen it in the current American legal climate and landscape for one main reason, and that is because there hasn't been a clear nexus between the racism shown by a cop to their actions, words, reactions, and the action of committing the hate crime, which is an attempt to kill or actually killing someone using a firearm or fire.
But I mean, I don't know yet. I suppose this is why we're here. But maybe I agree, because even if I pull somebody over because maybe I am a racist, is the shooting of that person always going to be because of their race in that case? Perhaps I pull somebody over because I'm a racist, but then that person reaches for a firearm. Is that shooting now still a racist shooting, or is that a justified shooting?
In that specific case, if the misdemeanant or the person that committed the felony was reaching for a firearm, it fits the description of two of the cases that the Supreme Court highlights and our law highlights where excessive force or force by the police is allowed. And those two cases are if the misdemeanant or the felon risks the lives of others or threatens the lives of others, including the police officer or other citizens in the vicinity by any sort of extreme force, then the police officer is allowed to use extreme force in return to subdue the situation. Or if there's a violent felon that's fleeing the situation and the last resort is then the violence. And there's an emphasis that justices in the Supreme Court have made historically for the last 30 years, emphasizing that the violence, especially in the form of firearms and shooting, should be the last resort a police officer takes. And therefore, in that case, it would be justified because it fits the law. And the police officer's actions abide by the principle of legality. Otherwise, in this case, the misdemeanant did not escalate the situation anyhow and was violated.
I would argue that he did escalate the situation by revving the engine.
The revving of the engine was in reaction to the cop opening the door and a pattern.
Did he open the door?
The Officer Campbell?
Yes.
Officer Campbell approached to open the door and...
But did he open the door?
Yes.
He did open the door?
Yes. Okay. And then Michael Jennings shut the door closed and proceeded to turn on the engine. However, it must be very clear that the car was stationary throughout this entire time being, and the deception by Officer Campbell that he was dragged by the car is an unequivocal lie.
I'm going to... Please.
So you believe that Mr. Campbell was going to follow Mr. Jennings until he committed a crime because he is a racist, according to your statements. You were going to wait until he committed an infraction or a crime so that then this Mr. Campbell, this supposed racist, could then act upon it? Or why did this shooting occur? Because he's racist and that's it?
No. So in this specific case, Officer Campbell was looking for an excuse to pull over Michael Jennings, as it says in the case.
But was he looking for an excuse to shoot Mr. Jennings?
No, but the events that unfolded were directly correlated, because as soon as he was pulled over, one of the first statements he made in regards to Michael Jennings asking if he was pulled over by a common concept called driving while black was that he said, "I can pull over anyone I want, whenever I want, especially your kind," referring to his race. And so that's where we see the racial correlation. And then we see the escalation of events where Officer Campbell proceeds to snatch his phone, breach of his First Amendment. He proceeds to...
Counsel, I think that I don't mean to speak for the court here, but I think that we all agree that him being pulled over may be because of race. But I don't know if, even if that is true, I don't know if that necessarily means that the shooting, which is the problem, is a racially motivated shooting. To me, the shooting, and this is why you're here, to me, right now, the shooting was because he was threatened by a vehicle which could have run him over. Right?
No, not at all. I'm glad you brought up the racial motivations, because motivations speak very, very clearly to what unfolded. And we see that in the time span of only 10 seconds, Campbell went from trying to open the door to firing the shot. And before those 10 seconds, for the several minutes that unfolded, we saw Campbell consistently misconduct, go with misconduct and police misconduct, breach of law, breach of constitutional rights, because Michael Jennings was black. And then we saw in 10 seconds from him pulling the door to him shooting, it's a very reasonable assumption to make that his feelings and emotions and motivations in those 10 seconds were probably a reflection of what he felt in the last several minutes. And so if we see Officer Campbell have...
Probably or were?
They were.
They were?
Yes.
100%.
I mean, you cannot speak 100% to anyone's motivation.
But is that not the problem right now? Is that you can never speak 100%, which is why this has never been applied to a police officer.
But you can make a reasonable assumption under the law, and the reason that it's important to emphasize that police officers should be under the Hate Crime Act, and this should be applied to police officers, is so that members of the African American community and other minority communities feel trusted, transparent, and accountable in their executive system.
But counsel, excuse me, are you suggesting that the victim revving the car had no effect whatsoever on the unfolding results?
In the case of a misdemeanant in our American law, in the case of a misdemeanant, even trying to flee, the police officer is supposed to then follow the misdemeanant and not escalate the tension by firing a shot. And that's what our law says. If there's a misdemeanor, then the police officer is supposed to let the misdemeanant flee, especially since it was...
But how do you know that? I mean, isn't it reasonable for the officer to assume that maybe he wasn't trying to flee? Maybe he was trying to run him over with the car, which is a deadly weapon. I feel like that satisfies the cause needed to discharge his own service weapon.
Yep, and that would be a fair argument. However, if we cite the case of Graham v. Connor, we see that the precedent states that the use of force by a police officer should be such that it depicts what a reasonable police officer would have done at the time. And a reasonable police officer can be one that follows conduct and follows the law and abides by department regulations. And
You're at 15 minutes, I'm just letting you know.
Yeah. And so in this case, we can say unequivocally...
Hold on, counsel.
Counsel, which theory do you think this court should adopt in judging whether there is a hate crime? Do you think we should adopt substantial motivating factor theory or the but-for causation theory?
I think it's very important to do the latter. I think
the but-for. The but-for causation, the but-for theory.
Yeah,
okay.
And that's because having a nexus between the racist actions of a police officer and the actions that unfold of the hate crime are linked directly. And that's why this Hate Crime Act should be applied very specifically in cases of police brutality such like this.
So I'm going to pose you a hypothetical again, and I think I kind of posed this already, but I do want your full answer here. I'm a police officer. I'm a racist police officer in this theory, okay? I pull somebody over because I don't like the color of their skin. Okay? I go, I approach the window, we speak, everything's fine. The person in that vehicle, the person I pulled over, does happen to be a murderer, and reaches for their firearm. And of course I shoot back because I want to preserve my safety. Is that shooting a racially motivated shooting?
No, because...
But you just said, I mean, but for, if I had not pulled over that person because he was black, I would not have discharged my weapon.
But that doesn't show a clear correlation between the violence you use, because the reason you use violence was not because he was black. The reason you use violence was justifiable under our law because you use it in reaction to him pulling a firearm.
Okay, and
which is not what happened.
On those grounds, would you agree that a car under the U.S. law can be considered a deadly weapon?
Yes.
Okay.
If used against the safety of the citizens in the vicinity or the police officer, yes.
Would you consider that by revving the engine that the police had reasonable doubt that the victim could use this deadly weapon against them and compromise their safety?
No, because revving the car for a misdemeanor in the case of Jennings, the police officer following the law should have let Michael Jennings flee and call for backup and then followed
No, but
Michael
this is not a matter. You mentioned that there's two specific circumstances where police
Mhm.
officers can make use of force. One, if they try to flee the situation, if the felon tries to flee, and second, if they risk the life of others. In this matter, I am asking you on the basis of the second exception. So could you say that the police officer believed for his safety to be compromised by the defendant revving this deadly weapon?
No, because police officers, as seen in the previous case proceedings, they're not supposed to put their hands inside of the car on the steering wheel, and that's a clear sign of misconduct. And therefore, if they do put their hands, our expert testimony in previous courts stated that it only puts them in a position where the only outcome would be an increase of violence and an increase of force. And therefore, they're instructed specifically not to put their hands on the vehicle such that they are dragged. And so the revving of the car would not mean a dangerous circumstance for the police officer in this situation. And at this time, I would like to delegate the rest of my time to Federico Operti after your question.
Yeah, I have a question for you. I'm interested in the nexus between the racist thoughts, which I assume are like beyond proof, like that happened, and the criminal conduct, because you say there has to be a nexus for we to call it a hate crime. You must have racist thoughts, a nexus between a crime,
yes.
right? So I want to hear, how do you interpret the facts of the case in order to build and argue in favor of that nexus? Yeah, that's the question.
Certainly. We saw the first instance where Officer Campbell said that I can pull anyone I want, I can pull over anyone I want, whenever I want, especially your kind. Then we saw and that was in relation to the question about driving while black. So he's referring to his race explicitly here. Then we see when Jennings pulls out his camera, a source of accountability for the cops' actions, plausibly getting evidence of the cops' racist behavior in relation to his misconduct, which then leads to the crime. We see that the cop slaps the phone away and increases the tension, which is against conduct in the CMPD, because they're supposed to de-escalate situations to have open communication. He escalates tensions, and then we see the cop ask Jennings to get out of the car without giving him reasonable a reason to do so, and he hasn't been told why he's been pulled over. And then in 10 seconds from that event, we see that the cop conducts misconduct by putting his hands in the car and then lying to his fellow officer, saying that he was dragged through deception, and then he shoots Michael Jennings.
I'm confused.
And then after...
You keep referencing this misconduct or not following procedure, but is that enough to satisfy hate crime? Is this not? Are we not delving into the territory of maybe an abuse of power issue, or perhaps maybe I don't know, just a general like simple assault?
In another case cited in our appeal, we say that the presumption of invulnerability in a cop, when they believe that they are invulnerable, is the driving force of violence in these cases. In cases of police brutality, when cops believe that they are invulnerable and they believe that they can abuse their power to an unreasonable extent, that's the driving force for the violence that occurs after. And at this point, I would like to delegate my time to Federico Alfred.
Sure. 8 minutes and 45 seconds.
Honorable Court, and may it please the Court, I would like to discuss the motion to deny the motion to suppress the evidence obtained during the search of Officer Campbell's locker.
Do you want to move the microphone up? You can position it to where it just so you don't have to keep,
Is it okay?
There you go. Perfect.
Okay, perfect. So this is not a complicated case. This is a case simply about justice. This is a case about police misconduct. This case is about accountability and responsibility among those who are supposed to protect and serve. This is about setting a precedent that police cannot hide behind the law. Police are accountable to the citizens that they protect and serve in every sense of serving them. The whole basis of the motion to suppress the body camera was that the Officer Campbell felt that Officer Graham's search of his locker infringed on his Fourth Amendment rights and his Fourth Amendment expectations of privacy. To violate Fourth Amendment rights, the search of the locker must be unreasonable. All of the recent jurisprudence on Fourth Amendment has not looked at specific tests nor specific theories, but rather the overarching theory of reasonableness in the circumstances. If we were to look at the circumstances, we have a case where there's clear exigent circumstances that justify, under all the recent jurisprudence, such as Katz versus the United States, and as well as United States versus Hitchcock, that there are exigent circumstances justifying the search of a locker due to the imminent threat of the destruction of evidence that may have occurred if Officer Campbell's locker was not searched. The main argument that the appellate court presented was that Officer Campbell had a reasonable expectation of privacy concerning his locker because there was no notice that locker searches could happen, that there was no written policy that stated lockers would be subject to inspection. Thankfully, we have a document directly relating to this, and despite what the appellate court claimed, the Charlotte-Mecklenburg Police Department specifically writes that that lockers in the police force are not private. They are subject to the laws of the police department, which include regular searches, as well as any searches related to investigations.
When was this code of conduct published?
This code of conduct was published in 2023.
So this officer in 2013 was supposed to have future vision, or how was he supposed to? Do you have any evidence that this was the code of conduct in 2013?
While there is no evidence that this was a code of conduct in 2013, it is.
So why is it being presented to this court?
It is being presented in this court because it is the most applicable current rulings.
But you can use case law that's current. But the thing is how can you possibly assume that what's in 2023, especially after we saw the George Floyd proceedings, how can you expect that what was in 2013 is the same as what is now? This officer did not have the reasonable, or at least what the respondents claiming is that they did not have a reasonable expectation of, did have a reasonable expectation of privacy. I'm sorry. So, sure, it may say now that it's subject to search, but I'm a little bit confused as to. Just clarify that for me.
So actually, this existed by law in 2006, and even if we are to not look at the direct
by which law?
By the Charlotte-Mecklenburg Police Department.
So it was a code.
Yes.
Okay.
And even if we are to look outside of the specific policies that dictated this police department, if we see the jurisprudence as well as the general theories on this matter, we see that he has no reasonable expectation of privacy. The United States versus Donato case, supported by the opinion, was upheld that the warrantless search was valid and allowed due to the exigible circumstances and previous regulation establishing the privacy of the mint lockers.
Sorry, but what's the procedure there? So any colleague at any time can just go into your personal belongings and check?
Of course not, but police officers, and specifically Officer Graham in this case, has the right to an independent investigation. That's what police...
Why if he's not a superior?
He doesn't need to be a superior in order to independently investigate an officer, especially when there's the exigent circumstance of evidence being destroyed, which can of course be assumed due to the fact that the evidence that would clearly that would clearly show what happened was missing from the evidence locker and was not in the charging station where it should be. He had the right to assume and under the exigent circumstances search Officer Campbell's locker, and there's a clear connection between his search and what actually occurred, which was finding the locker and finding the camera.
Counsel, we noted that Officer Graham was not involved in the investigation of the Jennings shooting case. So do you think this is relevant? Because Officer Graham was not responsible for this case. Do you think Officer Graham searched his locker as a colleague or as a police officer of the government?
So actually, he searched for it as a police officer. He searched it for it independently, which is proven in the jurisprudence to be something that is allowed. In the jurisprudence presented by the opposition, it is clear that in the case of United States versus Takata, the DEA agents were able to investigate and search someone else's private office, which had the employee's name on it. That's much more private than a locker that is subject to departmental searches. In this room, they found that the seizure and search of the room and of the office was allowed. What wasn't allowed and what constituted a breach of the Fourth Amendment was the filming and the installing of cameras. But this is not the case here. The case here is an investigation independently done in which officer.
I'm sorry for interrupting you. I'm just trying to understand your argument. Are you arguing that there is no expectation of privacy for police officers? Yes or no?
Sorry.
Are you arguing that police officers do not have any sort of expectation of privacy?
Of course not. Police officers have an expectation of privacy, as do any citizen. However,
where is that expectation of privacy?
In the Fourth Amendment.
No, but like physically where? In their office, at home?
In their office and in their lockers. And it does apply to his locker. However, even if this expectation of privacy existed, in the investigation and the exigent circumstances and the imminent threat of the destruction of this evidence justified the search and the breach of this locker. As a police officer, your privacy rights end where the safety and public of those who you serve begin. And I would like to call Anna as my for the.
Are you doing something else? Okay, you do have 1 minute.
So we believe that Officer Graham did not violate the Officer Campbell's Fourth Amendment rights because, first, even if he did not have a warrant, he had exigent circumstance presented by this case and probable cause. And secondly, Officer Campbell displayed an unreasonable expectation of privacy, and this is as previously established by the CATS test. First, regarding the CMPD regulations, it was founded in 2006 and then updated in 2023. But the bylaw considering the privacy was in the Code of Conduct in 2006. And it explicitly states that employees will not expect privacy in the locker area, and that these searches are subject upon work-related misconduct and also to retrieve property of the Charlotte County.
You can finish your thought.
Which is the body-worn camera is property of Charlotte County. Thank you.
I do want to just ask one quick question, and then sometimes we have a couple more.
Mm-hmm.
Just to confirm, is your argument that you do have the expectation of privacy, however, there was legal cause to search and seize those items?
No, our argument is that along with the unreasonable expectation of privacy, Officer Graham has probable cause to search his locker.
So you're saying that Officer, is it Jennings?
No, Officer Campbell is the main
Campbell. Officer Campbell. Officer Campbell's expectation was unreasonable. Is that what you're saying?
Yes.
It was a little too much of an expectation.
Yes, because if he read the policies that he was supposed to abide to when he swore an oath to join the CMPD, he would have been aware of this policy and this policy concerning the lockers and the BWCs. So he wouldn't have had that expectation in the first place.
Okay.
I have another question. This expectation, it is regarding your employer or is regarding anyone? I mean, do I have the expectation that no one is going to break into my locker? Like that my employer is not going to break into my locker? Or if some employee and equal in the hierarchy is not going to break into my locker?
May I ask a clarifying question?
Yeah, sure.
Are you is it within the context of the police department or just in general?
In the police department.
So within the police department, this expectation of privacy was applied to all employees. So regardless of superiority, they would all have the same expectation of privacy regarding the desks, the lockers, and I believe the evidence lockers as well, and the vehicles.
But for example, if someone who is not in the context of a police department, someone who is not a police officer breaches into my locker,
yes.
Am I covered by the expectation of privacy? Or is it the fact that the one searching was a police officer what justifies the...
Yes. So the person that searches the locker has to act in their official capacity as stated by the bylaws. So in this case, we argue that Officer Graham did act in his official capacity as a police officer, but if it was a random stranger that broke into the police department, then there would be a reasonable expectation of privacy.
Thank you. Final thing, just your question, a question for you, and it's a yes or no.
Yeah.
Just confirming,
Mhm.
if the law were to be contrary to the code of conduct, per
So
chance.
the Fourth Amendment, are you?
Sure.
Okay.
The Constitution
Okay.
contradicted it. Of course, the law would prevail over the code of conduct, correct?
Can I explain my answer?
Briefly.
Yes, but within the Fourth Amendment specifically, there are exceptions, and we find these exceptions fit this case. So
Sure, that's all I needed. Thank you.
Perfect, thank you.
You'll have 5 minutes for rebuttal after the respondents. We'll call respondents for argument.
Thank you, Mr. Chief Justice, honorable judges, and may it please the court. My name is Adriana Martinez Menendez, and I, together with my co-counsel, Ana Emilia Di Filippo, represent respondent Mr. Roy Campbell. Today we're talking about a transgression of the Fourth Amendment that has left our client unprotected by the most supreme law governing our nation. We are not just fighting for him. We're fighting for every Jack, Jill, and Jane who expects the Constitution to mean something. Down in the lower courts, we argued until our voices were hoarse, but they were not buying it. They let an illegal search slide like it was just another Monday. Well, Your Honors, it's not just another Monday for our client, and it sure isn't business as usual for justice. We're throwing Hail Mary with a certiorari because someone has to fight for the justice system to reinforce that the Fourth Amendment is more than just fancy words. It's a promise that when someone comes knocking, they must have a good reason, a probable cause, and sufficient authority. So I'm here to ask the court to take a closer look, for the court to take a leap into the future and consider how it would look like if we let this slip again. Let's not make the Fourth Amendment just another casualty in the legal battlefield. Let's make it mean something. My client is counting on it, and so are the people outlined in the United States Constitution who believe in justice.
Sorry, you mentioned that in order to breach the Fourth Amendment, one must have probable cause and sufficient authority. So which of the two are you claiming Mr. Grahams did not have?
Mr. Graham did not have any of the requirements under the Fourth Amendment. He did not have probable cause or sufficient authority. He merely had a suspicion based on racial biases, based on biases against his colleague because he did not like him.
Biases, even though they ended up being true.
So
tried to conceal evidence. You do realize that.
The issue
he changed up to his government lock that was given to him by a public authority to a personal lock to conceal evidence.
The issue is not whether there's a bias or not. The issue is whether the bias is sufficient probable cause for him to conduct an investigation. And furthermore, if it was sufficient cause, which is not a probable cause, did he have the authority to conduct this search, which he didn't have. He was not acting in his official capacity.
I believe that the Fourth Amendment allows for searches so long as it is from an employer or a, oh gosh, what was the other term? Employer or a supervisor. Is Officer Graham acting as the police officer in this regard, not acting as an employer, acting on behalf of the police department?
Your Honor, we consider that Officer Graham during the incident was not acting in his official capacity as a police officer, but rather he acted on personal motive, meaning that his personal biases led him to take that investigation, not in the full powers of conducting a police investigation, but rather based on personal biases to conduct a personal investigation.
As I understand it, the Fourth Amendment is only applicable for police officers and representatives of the government. So if he was not acting in his official capacity, but as a private citizen, wouldn't that mean that the Fourth Amendment is not applicable to him?
The Fourth Amendment is applicable to all citizens, and it covers the scope of the case. And we're not looking only towards if he had the authority or the personal capacity to, but also how he did it and with which authority. And he had no authority whatsoever to conduct this search.
Counsel, we also noticed that the police department had conducted an unannounced search of all officers' lockers about 1 year ago. Do you think this event to any extent affect the reasonable expectation of the officer in this case? Because the police department had finished such searches of the lockers before?
That is an excellent question, Your Honor. Thank you for mentioning it. When this search happened about a year before the incident of Mr. Campbell and Mr. Graham, there was a bigger ongoing investigation at the time. And not only that, but all of the police officers were notified that a search was going to be conducted in their lockers. So maybe they did not have a date and time, hey, tomorrow we're going to search your lockers. But they were a notice that there was a search going to be conducted and by the authority that had to conduct the search. And also there was an ongoing investigation, which in this case is also relevant because at the time of the incident, there was no ongoing investigation towards Mr. Campbell. There was mere suspicion, personal suspicion based on biases. So if they wanted to search the locker, they should have been on notice to all the police officers. There should have been probable cause. It should have been performed with sufficient authority, and they should have all been on notice.
But you contend, just to confirm, and please help me understand, you're contending that the officer acted as a private citizen. So if he acted as a private citizen, the Fourth Amendment doesn't even apply in this case, does it?
It is, let me rephrase, Your Honor, if I may. So he was acting in a capacity of personal biases, even though he is a police officer.
But he was acting as a police officer, as a government agent.
Yes, Your Honor,
Okay.
I apologize.
Sure. He's acting on his own biases. Yeah, yeah, please.
Sorry.
No, go.
No, I wanted to ask, but you don't think that, like, the fact that he was keeping evidence, which ended up being the most important piece of evidence in the case, so the camera, was probable cause for them to search his locker, which was, like, as we have already stated, a government-provided locker?
It might have been probable cause, but the due procedure was not followed. And that is the issue at stake, that it was an illegal search. And furthermore, not only an illegal search, that he caught the lock, another officer that did not have the authority caught the lock and went through the locker. He also stole this property, the body cam. That's not property of Mr. Campbell or Mr. Graham. That's government property, and that's a felony. He trespassed government property, and he stole government property.
And counsel, sorry.
No.
How do you reconcile that, counsel, with the bylaw stating that the claimants mentioned, stating that within police lockers there's no reasonable expectation to privacy?
We disagree because we do consider that there is reasonable expectation of privacy, and the mere manifestation of a lock in the locker manifests this expectation of privacy, and furthermore, not only in the locker itself, but in the contents of the locker. So even if they were to conduct a search to the lockers and open the lockers, the taking of the camera and the content inside the camera, that is in violation as well. So not just the locker itself.
But the camera is a police camera. It's
Exactly.
provided by them, and it was used as a piece of evidence, so they were not... It was not private property. Like, why would they not be able to take the camera and hand it in and use it
Because
as
they
evidence?
did not have probable cause or sufficient authority
Was
to
it
do
not
so.
probable cause your client going around making openly racist remarks and saying that just another one that can't breed again, that's not probable cause?
I apologize, Your Honor, but my client is protected under the First Amendment. He can have any freedom of thought or expression, and this does not mean that any sort of crime is related to his freedom of thought, religion, race, or any other comment that he may make. He cannot be amputated with a crime simply because of his freedom of thought.
Okay, if I'm going to pose a hypothetical for you, counsel, if that's okay.
Yes, Your
if
Honor.
I go to a police station and say, oh, I killed this person on November the 3rd, am I protected by the First Amendment?
No, because you're confessing to a crime.
No, I'm not confessing. I'm just saying it as a joke. Let's say, oh, I just killed this person on November the 3rd.
Well, a due investigation must proceed in that case.
But I am protected by the First Amendment, correct?
No, if it...
Yes.
I
am.
apologize, Your Honor. Okay.
That's
you're
okay.
right.
But does that entail that police officers in that case have no reasonable cause to think that I committed a crime?
They can think whatever they can. That is also protected under the First Amendment, but
But
that does not
regardless-
mean that they can conduct an illegal search on property.
But the First Amendment does not entail that protected speech has no consequences whatsoever, and there may be consequences outside of the First Amendment that follow a statement like the one I suggested.
Definitely, Your Honor, but then there must be a nexus between the comments and the action. And furthermore, if in this case we have explained that there is no nexus, because suppose that the targeting him, following him, waiting for him to commit a crime can be considered a speculation. But the stopping him because he infringed the law, he switched the lane without previous notice, that is an infringement of the code, right? So that's why he was stopped. He was not stopped because of race. He was stopped because he committed a violation of an act.
Counsel, I'm gonna say that I actually agree with you in that there probably was no probable cause, but I don't. Maybe I'm taking a different route from everyone else here, but I just don't even think that he was acting as a police officer. I think he was acting as a private citizen when he made this search, and I think that because when you make these types of comments, especially that comment that we saw about that lying racist, those seems like personal motives, and considering that he wasn't a supervisor, that he didn't go to a supervisor to ask or make their supervisor aware of these potential breaches, it looks to me like he just searched his locker out of pure spite, which I think would be classified more of a private action.
Yes, Your Honor, but for this we must also analyze what time was this performed at. So did he perform this illegal search at the time when he was serving in his official duty?
I would argue that he was not in his official capacity, and I'd like you to justify your argument. I mean, I'm posing this as partial hypothetical and partial.
Your Honor, I would say that for a police officer to have access to the premises, then it must be during working hours, and he should have access somehow. It's not like they let you in a police station at any time of the day or without anybody else around there. So it is a reasonable expectation to think that he did it during his working hours, acting as an official policeman.
What if we had the exact same set of facts, except Graham was not a police officer and was a janitor? Would this would still be a private action, right? He still has access to the premises, though, but he's searching the locker out of. Would that still be out of spite, or is he now acting as a police janitor?
Was he acting out of spite? Like, did he probably wouldn't even have?
I said same set of facts, except Graham is a
janitor.
Janitor and is cleaning the the only reason he has access to locker rooms is not because he's a police officer, but because he needs to clean the locker rooms.
It is still an illegal search, just maybe does not fall under the Fourth Amendment of the Constitution. But it still is an illegal search, and there is still an expectation of privacy, especially from a janitor. You expect that a janitor sees a lock in the locker, and he will not trespass that.
Okay, so let's say that the Fourth Amendment did not apply, just for the sake of argument. You're saying that even if the Fourth Amendment doesn't apply, even if it doesn't, which it does in your argument, but if it doesn't, then there is still, this piece of evidence is still inadmissible. Because even if you were acting as a private citizen,
there is a reasonable expectation of privacy.
But
in the context,
how could you possibly justify the inadmissibility? I mean, sure, that person should probably, get a fine for theft or something, but I don't see any reason that the court should find it inadmissible if the Fourth Amendment doesn't apply.
So we could maybe use the exclusionary rule, which mandates the government cannot use evidence gathered in violation of the United States Constitution. So even if it's not a violation of the Fourth Amendment, it's still a violation of privacy, because
and where is that in the Constitution, Counsel?
I apologize?
Where's the privacy statute in the Constitution?
I cannot cite that for you right now, Your Honor. I apologize.
Counsel, what also makes this case special is that this is a context in a police department. As we all know, the police department is meant to protect the general public welfare and public safety. So do you think the officers' expectation of privacy should be compromised to a certain extent because of this point? As we all know, this is a very special context in our police department.
If I may respond, and maybe if I don't respond to your question well, please let me know afterwards. But what I would say is that, for example, the CMPD directive that the petitioner cited could also be used to kind of make a reference as to what the expectation of privacy is. And so in this directive, it not only says that, it says what the petitioner has cited is that they shouldn't have a reasonable expectation of privacy, but they omitted a very important part, which says that to conduct these searches, and this is part 5, section F of the CMPD directives. So here it says that it must be performed with sufficient authority and notice. So any police officer has to read these directives and is aware of the due procedure of a search. So especially in the context of a police department, there is a reasonable expectation of privacy simply because you know the due process, simply because police officers are aware of how these searches must be conducted. Does that respond to your question, Your Honor? I apologize.
Yes.
Thank you.
Yeah, I have another question. I want to focus in the expectation of privacy. I want to focus on the privacy part. I'm struggling to understand why anyone can have an expectation of privacy when the property is not yours and it was never accessed through your property. It was the government's locker and the government's camera. It was not my backpack and the government's camera, or the government's locker, my backpack, the government's camera. There was never a breach in my privacy. I mean, in the officer's privacy. So, I just don't see how can you have an expectation of privacy when things are not even yours.
Okay, Your Honor, if I may respond, you have this expectation of privacy because you are aware of the due process. So you know that even if you're hiding a corpse in your locker, the due process to find that corpse is to have sufficient authority, be on notice, and have a probable cause. So it is not a matter of expectation of privacy based on the content inside the property. It's an expectation of privacy based on the due procedure to access these premises.
15 minutes, counsel.
Thank you, Your Honor. I now wish to delegate the rest of the time to my counsel.
One question.
Before you go, and
Yes.
if you have time missing, don't worry
Thank
about
you.
that.
Thank you, Your Honor.
Where is this procedure detailed? Like, where is the procedure that it must be followed in order to breach these expectations?
Okay, Your Honor.
of
First of
privacy?
all, it is outlined in the Fourth Amendment of the Constitution. It says that it must have a warrant, probable cause, and sufficient authority. And secondly, it can also be outlined in the CMPD directives that the petitioner has cited, Part 5, Section F, which says that there must also be probable cause and sufficient authority. So we have all of these requirements, not only in directives, but also in the most supreme law in our nation, which is the United States Constitution, Fourth Amendment. Thank you, Your Honors.
You may be seated.
Thank you, counsel.
Thank you, Mr. Chief Justice, and may it please the court. Today we present a counter-argument against the expansion of hate crime statutes to encompass police actions, emphasizing the importance of requiring substantial evidence to prove all elements of the hate crime in these proceedings. The question involves whether or not, when, if at all, can police officers' actions during the course of their employment be constituted a hate crime under Provision 18 of the USC, Section 249. We contend that it is important for us to exercise caution when it comes to holding officers accountable for split-second decisions made under a rapidly evolving, tense, and high-pressure situation, as was acknowledged by the appeal court. The standard of mens rea in this situation, as we all know, was not satisfied.
Do we know that? Because I'm asking you because, especially because the petitioner is referencing this kind of nexus.
Yes.
This, and I'd like to play around with this a little bit.
Mhm.
If you pull somebody over,
Yes.
and you do so because they are black, I mean, we are looking at this issue, which is that. I mean, yeah, like he should be in this regard. I mean, of course, he would be charged with a hate crime, right? Because go ahead.
Yeah. So there is a difference between a hate incident and a hate crime, and in this situation, although we might contend that there may have been a racist motive under or behind the stopping of Mr. Jennings' vehicle, Mr. Campbell did stop him after making an infraction, which makes this stop actually legal. So whether or not that was racially motivated is not relevant to establishing whether or not the shooting was racially motivated.
Question.
Yes.
If the hate crime at issue right now
Yes.
was about the traffic stop for some reason,
Well,
it wouldn't satisfy it completely, I know.
Exactly.
But let's just say that
it would be beyond the scope, and that's one of the main arguments that we contend.
Let me pose
Yes.
this hypothetical. Let's say that the traffic stop somehow, just to be stopped by the police counted as something for the hate crime, right? You just said that yes, there may have been a racial motive, but it also was a legal traffic stop.
Yes.
Would the hate crime statute apply in this hypothetical?
Well, no, because there must be for any crime, you must have the actus reus and the mens rea. And even if you have the mens rea, here there's no actus reus because the actual action
of the stopping was legal.
Does
So-
hate have to be the sole determinant in the hate crime, or can it be in part with something? Can it
So-
be hate and can it still be legal?
Mhm.
For example, can the shooting be legal but still be driven by hate? Can you not? Perhaps if I am a racist and maybe I'll shoot one person, but if it's a white person, I might just tase them instead.
I believe that and we contend that a hate crime has to be motivated by racial animus. And in this situation, which is the present case, we say that because there were other factors influencing the decision of Mr. Campbell to shoot Mr. Jennings, which were the altercations and the lack of compliance with the police officer's directions, and also the revving of the engine, as you questioned the petitioner on, that there is no but-for cause established for the potential racial animus that he held prior to this decision, because we have to look at the decision itself. We don't believe that the shooting itself was racially motivated, because it was right after Mr. Jennings had refused to cooperate with Mr. Campbell. And we might also add that Mr. Jennings was provoking the police officer, and disobedience is also against the law. So there was already a new crime being perpetuated by Mr. Jennings.
But does disobeying a police officer warrant the use of deadly force by the officer?
Well, of course not, but we don't, the petitioners also claim that this was an attempt to kill, and we don't believe that it was an attempt to kill. I believe that it was an attempt to stop Mr. Jennings from potentially fleeing the situation, and I believe that that is the discretion that each police officer is given to decide in those situations what the best course of action is. And although this might be seen as an abuse of force for the petitioners, we believe that if he was under threat, especially considering that he felt threatened by Mr. Jennings and Mr. Jennings' commentary, and also the fact that we could reasonably infer that that Mr. Jennings was not compliant, could also present a threat to Mr. Campbell. We don't believe that this was racially motivated, or that this use of force was necessarily unreasonable in that situation.
But as I understand it, the victim complied with the officer's instructions all the way until the revving of the engine.
No, he did not. He refused to get out of the car.
But he provided his documentation.
We don't know that for sure. That's not part of the case.
Okay, regardless, the police officer disrespected procedure on multiple occasions, including when he introduced his body inside the vehicle. And when he made use of this deadly force, whether there was intention to kill or not, I'm not sure whether that's incredibly relevant to the question at issue.
Yes.
The vehicle was not in motion, once again breaking procedure in these kind of situations.
The elements to substantiate a hate crime are very specific and are very clear, because as we know, when we're interpreting any sort of federal criminal statute, we must follow the rule of lenity, and we must also follow a very specific scope of interpretation that is in line with what the Congress had intended when they passed the law. And under the Hate Crime Act, what is at stake is an attempt or willful infliction of bodily injury. And so whether or not the insertion of the officer into the car is under the Hate Crime Act, we contend that it is not, and that even if it is perhaps an alleged diversion or departure from conduct, we believe that it can be seen as well as an escalation of the need for further and further force, because even if this police officer, if Mr. Campbell reached into the car, Mr. Jennings did not stop the car. And so that could be seen as also previous levels of force being used in trying to reasonably stop someone that, at that point, if he was not compliant, could have presented a bigger threat to the officer. Does that answer the question? Yeah.
Yes, thank you, Counsel.
Counsel, you are advocating that the race is a substantial factor which motivates the officer to pull over Mr. Jennings. do you think there are any other factors which motivates the officer to do so? For example, the facts shows that Mr. Jennings was young. He drove a very expensive car in exclusive district. Do you think these factors also motivate the officer to stop him and pull over him?
Yes, Your Honor, we actually believe that that is exactly what motivated Mr. Campbell to then stop, potentially then stop Mr. Jennings. So yes, we do agree with those facts that he noticed that there was something suspicious to him, whether or not racially motivated. And this is, again, the discretion that is afforded to police officers when patrolling and when ensuring that there's safety in the neighborhood that they're in. So does that answer the question, Your Honor?
Yes.
Thank you. So to continue, as I was saying, there is also a need to provide substantial evidence in order to substantiate the mens rea present in this hate crime statute. And there are two different types of mens rea that are present here. The first one is more of a general mens rea, which is the willful infliction of the bodily harm or attempt to inflict bodily harm. And the second one is the more specific mens rea, which has to do with the because of clause, which again we interpret as but for. But to quickly make a point about the willfulness part of the claim, the petitioners failed to also talk about this part of mens rea that is very necessary for this type of hate crime to be charged, and also it is evident in the way that it was written into the law and clearly shows the intent of Congress when drafting the law itself. And under under case law, we can see that willful can take many forms depending on the context in which it is in. And in the context of this particular hate crime provision, a police officer must have acted in a voluntary, intentional way, and he must have known that the conduct he was carrying out was unlawful, with specific intent to do something to disobey the law. And as we've established before, there is no way to establish this willfulness if he had reasonable doubt or if he had a reasonable fear that Mr. Jennings had provoked in him, and that could lead him to believe that he was not only not breaching the law, but also making sure that it was enforced by not letting a potential criminal or a potential suspect flee.
How do you reconcile, counsel, that it was involuntary and that there was no intent to breach a law with Mr. Jennings' later statements suggesting that it was a good thing that one of them, was along the lines of one of them less is breathing now or something like that?
Well, Mr. Justice, I would actually, thank you for bringing up the posterior comments, because these are very important, and as we've contended, especially in the petitioner's brief, that this is a part of the evidence that could substantiate the hate crime and the motivation. However, we not only agree with the Court of Appeals, which said that this could only, it wouldn't be able to show motive, but it would be able to show just the effect. And also under the section 4710 of the Hate Crime Prevention Act, which was the one that established the statute that we're discussing today, it is called rule of construction. And under the fourth clause of this section, it says, free expression, nothing in this division shall be construed to allow prosecution based solely upon an individual's expression of racial or any other protected rights beliefs, or solely upon an individual's membership in a group advocating or espousing such beliefs, as this would go against First Amendment rights of that suspect. And so here we see clearly that there is not only a violation of Mr. Campbell's First Amendment rights, but we could also contend that if we were to interpret that these comments could be substantial evidence to substantiate this hate crime, it would actually go against the congressional intent that is clearly shown in this section of the Act when they passed this type of hate crime act.
Thank you, counsel.
So
you are at 1 minute.
Okay. So to conclude,
we would say that in order to substantiate the hate crime act, one could not rely on the membership and speech of the defendant to prosecute defendants, and it would only be a purposive interpretation that is contrary to the rule of lenity, which establishes that we must interpret things that not in a way that goes against the defendant, but against the state, and it would directly contradict the neutral and objective criteria for guiding prosecutorial discretion and Section 4710 Rule of Construction of the Hate Crime Prevention Act. So for these reasons, we ask the court to affirm the Court of Appeals judgment. Thank you.
Thank you. We will hear a 5-minute rebuttal from the petitioner.
Dear Honorable Justices, I will address the points made by the respondents in chronological order. The first point made was that the investigation employed was that there was no ongoing investigation. However, the fact was that the police officer, when in a traffic stop altercation, when a police officer shoots the felon or the misdemeanant, and an ongoing procedure and investigation is started almost immediately.
But that's not an investigation into. That's not that you're speaking about an investigation into the cause for the shooting. I'm having trouble linking that to an investigation into the motives behind the shooting. I think the bigger question for the investigation that you're referencing is more of an investigation about the general conditions, and they're pretty standard. I think that it goes through on every single time, right? This specific investigation is, or this specific thing about the body camera, I don't know if that necessarily suffices.
And we would contend with that if there was no deception shown actively from Officer Campbell. So we saw that the reason Officer Campbell said he used excessive force was because he's dragged by the car. But in every previous court that has ruled on this case, we've seen expert testimony that said that there was no evidence whatsoever that says that he was dragged by this car. And so that's the first indication of deception that was seen. And so Officer Graham had probable cause, but furthermore, he fit the exception in the Fourth Amendment, which was that this was an exigent circumstance, and it could have led to destruction of evidence that would have altered the ruling in this case completely. I mean, without the body cam, we wouldn't have any evidence linking Officer Campbell's racial behavior to his very evidently seen extreme use of force in a case where it shouldn't have been used. Next, we see that even if he was investigating independently, he would be allowed to do so because the opposing counsel said that the search was unfounded or not fully authorized because he wasn't a superior force in the police department. There's two things that stand on our side here. The first is the US v. Takata ruling, and the second is the Hine versus Illinois hearing. And they state that an officer can act independently and he doesn't have to be authorized by a superior because the output of the investigation is still very valuable to the ongoing proceedings currently. And so without this body cam, and if this evidence was destroyed, making it an exigent circumstance, that would be very, very crucial, and we would not be able to rule on this, as it would not be a fair process of adjudication for Michael Jennings, who was shot in this trial. The next point that we would like to bring up is that the cop that we see when the cop is when we see Officer Graham search the locker of Officer Campbell, there was very clearly no reasonable expectation of privacy because of the CMPD directives, which makes this case very simple on its merits. Because if Officer Campbell joined the CMPD, he had to take an oath and abide by the directives.
If there truly was no expectation of privacy, why would they even have locks on the lockers?
The locks on the lockers were to protect the personal goods of officers at their workplace. However, there's two things that are extremely
But it's still, I mean, yes. But so you do contend, and it protects those personal goods from everyone.
It protects the personal goods from everyone unless those goods go against public safety, which means they could be a risk of public safety.
But how would you know if it's behind a lock whether or not the goods are for public safety or not?
And that's why we allow police officers
1 minute, by the way,
to have probable cause and fight for their reasonable suspicion on someone. Now, to address the Hate Crime Act, we see that the respondents brought up mens rea and actus rea, and we see that they're very closely aligned with one another, because we see the guilty mind as something that is contended by the respondents. We see that the racist beliefs is something that we see consistent, and the actus rea is when we see the officer continuously escalate the tension in the situation when there's a clear indication in the CMPD directives to de-escalate and have open communication. And by escalating this and increasing the amount of misconduct, we see that he increases the tension just to use violence against someone, and this is then seen through his reaction, which speaks to his motivations, where he states that now there's one less to breed. Thank you for your time, Your Honor.
Before you sit down, I have one last question.
Mhm.
The officer performing the search, was he looking for the body cam? Was he aware of its existence and its importance to the case, or was he just performing a fishing expedition?
No. Officer Graham was aware of this. Since he's an officer in the CMPD, he noticed, we have a reasonable assumption to believe that he noticed that the body cam was missing from the docking station, which is something that all police officers are supposed to report and then upload for a live stream for other police officers to view as well. And so he didn't abide by, Officer Campbell didn't abide by this, which gave Officer Graham probable cause and reasonable suspicion on Officer Campbell to then undergo this investigation. Thank you for your time, Your Honor.
You're dismissed. Ladies and gentlemen, session 2 has come to a close, which means that the competition has come to a close. This is how this is going to work. We're going to break for probably about 20 minutes for deliberations. In 20 to 25 minutes, we'll return. We will give out awards, and I will announce the location of the after party. With that being said, we are going to adjourn, and we will return in 25 minutes, which means be back here at 7:20. Ladies and gentlemen, please grab a seat so we can announce these awards. Or anyway, okay, here we go. First of all, just so you know, decisions were made entirely by the justices. Elsa, i.e., was not involved in the decisions. It took a majority vote for any of the awards to pass, and et cetera. First off, in terms of actual rulings, for the first case in Alex versus Matilde, we find that the evidence was inadmissible, and thus the hate crime charge was not satisfied. For the second session, for the second round, we find that the evidence was admissible, however, that the hate crime was not satisfied. Okay, those are the rulings. Now for our awards. For our first honorary distinction for work throughout the trial process, it goes to Noama, if she's here. For the second honorary distinction, it goes to Claudia from Alex's team. The third honorary distinction goes to Frederico from Vance's team. You had some heavy advocates in that room. One heavy advocate in that room for sure. Our fourth honorary distinction, let me make sure is Leah. Leah? Yes. Not here? Not here? I thought I saw her like sitting over there somewhere. Okay. Oh well. Fifth, Electra. I also want to comment on this one, as Electra had an original team of 6 people, which were partially final year students, and they all dropped on her, and it was just her and her 2 teammates. Honestly, you all 3 of you deserve this honorary distinction, but I'm giving it to you. Thank you. And last but not least, Anna Di Filippo. Congratulations. Now we have 2 Mitchell L. McLean Awards for professionalism. The first one going to Mathilde. Congratulations. And the second one, for 2 years in a row, Anna! For the written briefs, we... Now... Oh, okay, got it. For the written briefs, we gave a best written brief per round, okay? So for the first round, the best written brief goes to the respondent, to Mathilde's team. And the best written brief for the second round goes to the petitioner. Okay, now we are at the second place title. We have enough for all of your teammates, by the way. The second place by a margin of 1 vote goes to Vanch's team. Congratulations. And the first place team overall goes to Anna Di Filippo's team. And now we have our final award, which is Best Attorney. And there were 2 Best Attorney titles because they could not make a decision. Best Attorney numero 1 goes to Vanch. And Best Attorney number 2 goes to Adriana Martinez. Congratulations to everyone. All teams did absolutely phenomenal. It was extremely difficult to make these decisions. I am going to hand the microphone. Do any of you want to make any comments, perchance? Any comments? Any comments? Okay, so, ladies and gentlemen, the Autumn 2023 Mitchell & McLean Trial Competition has come to a close. Once again, congratulations, everyone. Have a wonderful rest of your semester. Ladies and gentlemen, remember this is at 9:45